you, Suren sir. Your dedication towards SCC is indeed quite infectious. We are also honored to have with us Justice Sanjay Kishan Kaul and Justice C.T. Ravi Kumar, Judges, Supreme Court of India, and Justice Rajiv Shakdher, Judge, Delhi High Court. Thank you for being here, sirs. Next, I would like to call upon Mr. Arvind P.Datar to say a few words on the occasion.
Honorable the Chief Justice of India, Justice Ramana, Honorable Justice Nagarathna, Justice Vikram Nath, Justice Maheshwari, Justice Sikri, Justice Lahoti, and Justice Shakdher. We have very pleasant memories of appearing before him in the Madras High Court, and all distinguished members of this audience. I join the chorus of congratulations to the entire EBC team for undertaking the publication of all the volumes from 1950 to 1968. With this, the gap will be complete and they'll have the full SCC set from 1950 onwards. I had the occasion of seeing some of these volumes, and what will be particularly useful to practitioners is that they have taken care of pointing out how a particular case has been discussed, referred, not just saying overruled, reversed, etc. For example, in the case of AK Gopalan, they have specifically pointed out which part has been overruled in bank nationalization, which has been overruled in Shambhunath Sarkar, which has been distinguished in Maneka Gandhi. So these volumes have been very well prepared, and the editorial notes are really going to be extremely useful to all the practitioners confirmed. The two new volumes, the present set, will now represent the first 2 decades of the Supreme Court, which was indeed a remarkable period where the most important landmark judgments were laid down and which continue to be followed. I remember when I just joined the bar in 1980, just a few days after I joined the bar, a very old senior lawyer saw me working in the library and he said that, just note 2 things. Take the 15 years digest, 1950 to 1965. We had the 15 years digest, then we had the quinquennial digest thereafter. So he said, please take the 15-year digest and please see the important judgments which are mentioned in those digests in Constitution. And if you read from 1950 to 1965, you will know enough of constitutional law that it'll help you in good stead. The second piece of advice he gave me was, All India Reporter had these volumes of Privy Council, published volumes of Privy Councils. And there the index would give them single star, double star, triple star. I don't know if the youngsters know about it. So depending on the importance of the judgment, they would be star marking. So he told me that go to these Privy Council judgments and please read the starred judgments. I took the advice to heart and it proved useful. Now, a Supreme Court is not just the building, but also the judges and the lawyers who make it. And when I read parts of it, you really feel not only the great judges, Mahajan, Patanjali Shastri, Mukherjee, but also the great lawyers like Setalvad, Daftari, M.K. Nambiar all seem to come alive. So when we read these judgments, we are not only going to see the great judgment, but also the great arguments which were made at that point of time. Now, what was particularly fascinating to me was, if you read, for example, Champakam Dorarajan, you will find that in those days, without the internet, the kind of scholarship that has gone into these judgments, because our constitution borrowed from the US, Canada, Australia, Ireland, Japan, and so on. So it was a great amount of research that was done. And at this stage, I will just suggest to the EBC team, if you can, when you prepare a note, you're not only in editorial notes, but see if on important landmark judgments, if you can go to the High Court judgment and make a comment on it. Because I also feel, for example, Gannon Dunkali's case, 58 Supreme Court, the Madras High Court judgment of 54 Madras is outstanding and is worth commenting when you're making the new edition again. Take Anwar Ali Sarkar. This was a judgment from West Bengal, but you must see the 5-judge bench of the Calcutta High Court and Anwar Ali Sarkar, which is equally remarkable. So while we're preparing this, one suggestion is you could perhaps make a comment and see those landmark High Court judgments which can be commented upon. Now, in the short span, I've been given 10 minutes, so I just thought that I will make a mention of some of the important dissents which had been mentioned here. and which to me really are the life and spirit of this great Supreme Court. Of course, the first dissent we have all know is the great dissent of Justice Fazal Ali in the A.K. Gopalan case, where if you now look back, contrary to what the remaining 5 judges said, it was a bench of 6 judges, there were only 6 judges at that time, till Chandrasekhar Iyer joined in September 50. He was the person who dissented, Mahajan dissented partly, but his depth, his vision of constitutional law, and he said that, look, please don't see preventive detention in isolation. Don't take Article 21 separately, 22 separately, 19 separately. These are all a harmonious whole, and unless you see them integrated, you'll not really decide the importance of individual liberty or personal freedom. And his vision proved right, where almost 20 years later, the bank nationalization case said that, look, you must see these articles in the thing. Now, according to me, in my humble opinion, the greatest judgment, not just the greatest dissent, but the greatest judgment of our Supreme Court is the dissent of Vivian Bose in Anwar Ali Sarkar. This judgment was delivered on the 11th of January 1952, exactly 70 years from now. What was that case? 50 dacoits, 50 armed men raided a factory in Jessop, the Jessop factory in Dum Dum. They were caught and convicted under West Bengal Special Ordinance 1949. Now just imagine the kind of public outcry, and for a man to dissent and say that the conviction should be quashed requires tremendous amount of courage. Mind you, the Calcutta High Court struck it down, but when it came to the Supreme Court, by this time Chandrasekhar Iyer also on the bench, 6 said that reverse the judgment of the Calcutta High Court, but Vivian Bose alone gave what is perhaps the most masterly piece of judicial writing. And I say this with a great sense. I mean, having written some books, I've had the occasion of reading several judgments, but nothing comes anywhere close to this particular judgment. If you take the SCC online of Anwar Ali Sarkar, Vivian Bose's judgment starts at para 81 and ends at para 98. Just 17 paragraphs of 4.5 pages. Justice Bose discusses the importance of not only Article 14, but also the importance of the Constitution, constitutional values in a sovereign republic. For example, I have noted what he says is that after discussing the scope of these provisions, he then asks the question, he uses the word that our Constitution is not a mummified manuscript. It's not a mummified manuscript, and he says that this living Constitution, he asks the question himself, does the classification offend the social conscience of a sovereign democratic republic? So he elevates a challenge to the level of a social constitution. And then, para 98 is the conclusion. And these words I remember again and again and again. He simply says, when the froth and the foam of discussion is cleared away and learned dialectics are placed on one side, we reach at last the human element, which to my mind is the most important of all. And then he says, I'm not worried about 40, 50 men attacking the Jessop factory. But what is the reason you'll distinguish these people from other convicts? What is the reason you'll try them separately from the others? This is not permissible in a sovereign, civilized, democratic republic, and on that basis, he sets aside the conviction. I always believe that apart from the Law Day pledge, I think all of us must read these 17 paragraphs at least once a year, so that we'll know what a great instrument our Constitution is and what a great judge Vivian Bose was. In fact, he also used the word cribbed, cabin, confined, which Justice Bhagwati used in Roypata, was actually used by him in Ram Singh's case in 1952. Now, just 2 more dissents because of lack of time. I think the other important dissent, which I really love, is the dissent of Subba Rao in Khadak Singh's case, where despite the person being of very unsavory character, he says, I'm not going to decide the case depending on the petitioner before me. We are concerned with a much higher value. And then he discusses what's the meaning of surveillance, what's the meaning of liberty, what is the meaning, why a man's home is his castle. And that great statement that if we don't accept this principle, the entire country can become a jail. Now, just one more point, how these people have molded this relief. All of us would have heard this case of Khajur Singh. I always found it being in Chennai, Khajur Singh was always very, very interesting. In fact, to tell you one important point, there is a good exercise case on whether you can use the definition in one act in another act. And the name of the case is Barfi Devi. So, like Khajur Singh, this is also another case which stuck in my mind. Now, Khajur Singh was concerned with the question whether Article 226 could lie where against the union government. You know, that time government was in Delhi and the only case was Punjab. The majority said, in Saka Rao, he says, no, you have to go, the High Court has no jurisdiction beyond its territory. If the officer is outside your territory, then it's over. But Subba Rao, in another outstanding judgment, he says, no, this is not the way to interpret it. And if you read the judgment, the judicial craftsmanship is such, he says, where is the union government? The union government is all over India. And to my surprise, he refers to Order 27, Rule 3, read with Section 79 CPC, and says, the union government has no address. If you see the CPC in the plaint, the union government has no address. You simply refer to the union government, that's all. We may put North Block, but that is not necessary. So then he says that, look, the reason why every High Court has a jurisdiction is not where the officer is situated, but what is the effect of his order. If his effect of his order is in Tamil Nadu, then the Madras High Court has jurisdiction. Now, these are the great masterly dissents which I noted, and I thought that I'll share it with you. And looking forward to these volumes. They will fill an important gap. And Dr. Malik mentioned that he has also referred to many judgments which have not been covered. This is going to be a virtual treat for all of us. And of course, I can tell him confidently that out of the various legal websites searches we do, SCC Online is perhaps the most user-friendly search of all. Even compared to Lexis or Westlaw or something, this is the most user-friendly. So I think I join all of you in wishing SCC all the very best, and we look forward to your completing the set, and it will help us in our legal research. Thank you so much.